Trying to figure out the Utah criminal justice system can be, well, it can be a lot. Especially right after you've had your first day in court. You're probably left wondering, okay, what happens now? Today, we're going to clear up that confusion and talk about the very next step, the scheduling conference.
All right, so you've had your initial appearance, you stood in front of a judge, and now you have another court date on the calendar. But what is this next date even for? It's a super common question, and we're going to get you the answer right now. You know, it helps to think of your case kind of like a timeline. You've done step one, that's the initial appearance, and you know that down the road your case continues. But what about that big giant question mark sitting right in the middle? That next meeting with the judge? Well, that's your scheduling conference, and it's the key to everything that happens next. So that big question mark on our timeline? That's called the scheduling conference. Let's dive in and define exactly what this hearing is really all about.
Okay, so at its heart, a scheduling conference is pretty much exactly what it sounds like. It's the court date where you and your attorney simply report to the judge how you plan to proceed with the case. This is not a trial. It's just a moment for your lawyer to officially announce the strategy you've both decided on. That's it.
Now here's a heads up, something that can be a little confusing. You might hear this hearing called a couple of different things. The court might call it a waiver hearing or a decision to preliminary hearing. Don't let that throw you, okay? They're all talking about this exact same court date. It's all about deciding what comes next. So you're probably thinking, all right, so what am I supposed to be doing between my first court date and this next one? And that's a great question. The truth is, a ton of the most important work is happening right now, but it's mostly behind the scenes, being handled by your attorney.
In that gap of time between hearings, your lawyer is really busy. They're focused on two major things. First, they're gathering all the evidence. We're talking police reports, witness statements, you name it. And at the exact same time, they're opening up a conversation with the prosecutor to start negotiating. This is where they start to explore what the potential outcomes could be for your case.
And this right here, this is maybe the most important part of that whole negotiation process. The entire goal is to see if a deal can be reached that is, and you really got to hear this, acceptable to you. You're in the driver's seat. Your attorney is your advocate, working to find options that you, personally, can agree to. So all of that behind-the-scenes work, the evidence gathering, the negotiations, it all leads up to this one single hearing. And honestly, the best way to think about it is like a major fork in the road for your case. Yeah, that's exactly it. Think of it just like that. At this hearing, your case hits a fork in the road, and the decision that gets made here isn't just some small procedural thing, it literally determines the entire path your case is going to take from this point forward. So, what are the two possible paths? All right, here they are, your two options. Path A is resolution. This means that through all those talks, you and your attorney have decided to work toward a plea agreement. Path B is the hearing path. This means you're not taking a deal at this time. Instead, you're asking the court to schedule a preliminary hearing, which is where a judge decides if there's even enough probable cause to keep the case going. Okay, so you've made your choice, you've picked a path. What happens right after that? Let's quickly walk through what happens next, whether you choose path A or path B. It's actually super straightforward. If you choose path A for a resolution, the next step is getting that plea agreement in writing and setting a new court date for what's called an entry of plea. If you go with path B, where there's no resolution, the next step is simply getting that preliminary hearing put on the court's calendar. That's it. And this is so important to remember. This scheduling conference, it's not the day you argue your case. It is not about determining guilt or innocence. It is 100% a strategic procedural hearing to tell the court which of those two paths your case is going to take. Just understanding that can take a huge weight off your shoulders. Which brings us to the final, most important question that you're going to discuss with your attorney. By understanding the evidence, the negotiations, and these two very distinct paths, you are now in a much better position to make an informed decision. So, which path will your case take? Knowing the answer is the key to moving forward with confidence.